G'day and welcome to another tax talk. My name's Henry. Today we'll be looking at the case of Dingwall versus the Commissioner of Taxation. It's a 1995 case in the Federal Court of Australia. Turning briefly forward to what we looked at last week, it'll be useful in this context, is the case versus Dolby versus Commissioner. Very quickly, Dolby versus Commissioner, there was a shareholder, they paid half the amount up front and then they're required to pay half the amount later, and there was a fixed date for that. The court found that the time in which that they incurred the liability, or the time which set the for indexation purposes, was the time at the beginning, the first date, not the second date, on the basis that they had incurred the liability from the very beginning. Now, turning to this case, it's in contrasting it. So the facts of this case was that it was in 1985. The shareholder was an employee of a company called Southern Farmers Group Limited. And he received 75,000 shares, and they were partly paid to 1 cent. And then later on, he received another parcel of about 100,000 shares, again, partly paid to 1 cent. Now, it's interesting, I suppose in the alternative, what they could have done, if you're looking at Part 4A perhaps, is that they could have issued these shares as part of an employee share scheme, in which case immediately the taxpayer would have incurred income, but that didn't happen here. So they set up a system where the taxpayer would get 2 lots of shares. They would be worth $4.50 and $5.60 for each of the different lots at different time periods. And essentially they wouldn't pay income tax on it, but they would have the benefit of the share, and the employee would only have to pay 1 cent per share. And the employee paid about $1,750 in total for the 175,000 shares, and there was a huge amount left unpaid. The shares, there was a takeover of the company, which the taxpayer worked. Industrial Equity Acquisition took over the shares, and essentially it went into a contract with the taxpayer to buy his 175,000 shares off him for 1 cent each, or $1,750. So from a monetary point of view, the taxpayer has received, has paid 1,750 and then receives 1,750 back. But he was actually claiming that the market value, or the loss of his shares, was something in the range of $895,000. So the taxpayer was claiming a huge amount of loss on these shares. And of course, I think the commissioner objected to this. The taxpayer was essentially claiming that the liability to pay the debt, or the outstanding premium, the difference between his 1 cent and the actual market value of the share, was due and payable, or he was required to pay that under the Act. And the commissioner was saying, well, you didn't pay that, you didn't record it as income, and therefore your cost base should be 1,750. And you received 1,750, and therefore you make zero capital gain. The court found in favour of the commissioner, and that was on the basis of the terms of the purchase of the shares in the first place. So really, when the shares were issued to him, there were only certain times when the company could call on the unpaid amount of the share, and that was when an employee who holds a share, so the taxpayer, stopped being an employee as a result of death or insolvency. There was 2 years after death or insolvency, the winding up of the company, or that the employee was seeking to transfer his shares to another employee. So this requirement to pay under the share offering, was highly contingent on a number of other factors, and the court found that there was actually no current liability on the taxpayer to pay the outstanding amount, or the difference between 1 cent and the $4.60 or $5.60, depending on what time it was. So the court actually said, and it referred to a case called Tuckman v. Dunlop, a 1958 case. And then in that case, Dean J. said, when does liability commence? The final words show that the liability is enforced by making calls, and that the debt then becomes payable. The liquidator could not sue for calls until they have become payable by making a call, so that the cause of action would not arise until the call was made. And so in this case, the Commissioner was arguing that essentially the call wasn't made, couldn't be made, and therefore no liability was incurred. Conversely as well, the Commissioner said that you didn't pay income tax on it. You could have declared it as income, in which case, sure, that would have been your cost base, and then essentially would have made no capital gain. And the court agreed with that. And the other thing was that when the company, if there was a liability from 1 cent to $5, that $4.99 was a debt supposedly owed by the taxpayer to the company. And so the court said, well, you've sold them for 1 cent, but you've also discharged your liability if you had one. Therefore, you've made a gain of $0 still. So either way, you're not going to get a capital loss of $895,000 out of nothing. And the court said that unless a call is made, the unpaid amount and therefore the requirement to pay will never ripen into the present obligation to pay either presently or in the future. For these reasons, I've concluded the taxpayer did not have at any relevant time a requirement to pay any sum on account of uncalled capital or unpaid premiums. So that's this case, Dingwall versus the Commissioner of Taxation, and you really need to go into the contract and into what the obligations of the taxpayer were in order to determine whether the amount was income or capital. Thanks for joining me. See ya.